If the Supreme Court blocks Trump's tariffs, what comes next? In a press briefing, President Donald Trump warned that a loss at the Supreme Court would be devastating for our country, as it could overturn the most expansive tariff regime his administration has pursued. The prospect of a defeat grew more tangible after Wednesday's hearing, where justices from both sides expressed doubts about the legal footing of the tariffs. Trump admitted that, should the court rule against him, his team would need to devise an alternative strategy, effectively reshaping the way he imposes trade barriers. The president's current approach leans heavily on the International Emergency Economic Powers Act, a statute that enables rapid tariff actions without the typical procedural hurdles. Through this mechanism, he has slapped reciprocal duties as high as 50% on nations such as India and Brazil, and even reached 145% on Chinese goods earlier this year. Those measures have already generated roughly $90 billion in revenue for the US Treasury, according to customs data. Yet, even his most vocal opponents do not anticipate a complete retreat from tariff policy. Analysts at Goldman Sachs argue the administration will likely shift to other legal authorities, meaning that foreign partners may see little practical change despite the courtroom outcome. The real shift would be in the legal instrument used. The administration could turn to several alternative statutes. Section 122 of the Trade Act of 1974, which permits a president to impose up to a 15% tariff for up to 150 days to address severe balance of payments deficits without requiring a preemptive investigation. Section 232 of the Trade Expansion Act of 1962 provides a national security basis for tariffs, but mandates a Commerce Department investigation before any duties are levied. This was the foundation for the wide-ranging steel, aluminum, copper, lumber, furniture, automotive and parts tariffs imposed during Trump's second term. Section 301 of the Trade Act of 1974 empowers the U.S. Trade Representative to investigate and respond to unfair trade practices, a slower process that includes public comment periods, but has no ceiling on tariff magnitude or duration. Finally, Section 338 of the Tariff Act of 1930, never used before, would allow the president to levy up to 50% tariffs on imports from countries deemed discriminatory, though such a move could breach World Trade Organization agreements and provoke retaliatory measures. In short, even if the Supreme Court curtails the current tariff framework, Trump retains a toolbox of legal avenues